But aside from that, he told me to avoid all that legal issues, he'd rather plead to time served.
I got to get him back.
I can get him on video on Monday.
No, but we need thumbprints. We need signatures. We can never do a plea remotely. They have to be here. What I can do, no. I know, no, but I'm not. I need his thumbprint. I need his signature on the plea paperwork because we can't do that remotely.
Okay.
Hey there, welcome to the Courtroom Files. So we're on record that we try really hard not just to entertain, but to also educate. And to that end, we try to bring you all sorts of different scenarios that we see in the courtroom, not just the same thing over and over, just with different faces. And this is yet another totally different thing. So we have a defense attorney who specializes in immigration, and his client was in Judge Fleischer's court, and he was given a $1,000 bond, and he had things he had to do while he was on bond. But once he got out on the bond, ICE picked him up. So ICE has him in custody, and now he is subject to a bond forfeiture hearing in Judge Fleischer's court because he hasn't gone through with the requirements of his release, because he can't, because he's in ICE custody. So a whole thing ensues about how do we get this guy back into Judge Fleischer's court to deal with that, but ICE seems to want to just deport him. So this thing goes on over the course of a couple of days. There's a lot to it. It's probably going to be a little longer video than what we normally do, but stick with it because at the end, the whole thing starts to go a little bit south for the defense attorney. And that is really interesting when you get there. So try to stick with it and check that out. And let us know at the end what you think of what's going on here, because it's complicated. And for the record, we don't post this video to debate the current immigration situation. That's for another place. Here we talk about court and we talk about the laws around it. Whether or not the man should be here isn't as issue. We're more interested in how is the law and the courts dealing with the fact that he is here and how we navigate it. That's what we want to discuss. So please let us know your thoughts in the comments. Subscribe to the channel if you haven't already. Put a thumbs up on the video if you like it, and let's roll the game film.
Thanks, Greg. That was
Good morning, Judge. Can I approach on the off docket very quickly?
What's your cause?
This is 2529290.
I mean, my next step is going to be a bench request.
Perez. It's set for a bond forfeiture hearing on Monday. Here's my issue with this case, Judge. Mr. Perez posted a $1,000 cash bond. Upon posting the cash bond, he went to ICE custody. Okay, he's in ICE custody. He's already been removed before. All they do is reinstate the order. He's waiting for a seat on the plane. Now,
You have proof that he's actually in custody that you can show me?
yes, on Monday. Well, I mean, I can pull it up right now, but on Monday I can.
There's no sense in waiting till Monday. If we know what's going to happen now, there's just no sense in waiting until Monday. We can take care of what we need to do now.
But here was my question. Okay. If this court is inclined to revoke based on being in ICE custody or the bond condition violation, I was going to ask for a court reporter because I think it's a good issue for our appellate division. I've talked to the division. I don't think an involuntary violation is a basis for a revocation. But aside from that, he told me to avoid all that legal issues, he'd rather plead to time served.
I got to get him back.
I can get him on video on Monday.
No, but we need thumbprints. We need signatures. We can never do a plea remotely. They have to be here. What I can do, no. I know, no, but I'm not. I need his thumbprint. I need his signature on the plea paperwork because we can't do that remotely.
Okay.
I can bench warrant him here, and we can get him back.
I don't see a basis for the bench warrant, Judge. Bench warrant's got to be he violated a court order. I don't, if he's going to.
I'm telling you that to help you to bring him back.
No, I understand. If you bench warrant him, he's coming back. He doesn't want to come back.
He doesn't want to take care of this? Because I'm telling you, if he ever wants to come back to the United States, it's going to be such a problem for him.
Judge, there are some people, look, I can tell you in the federal context, right? If you have a defendant charged with 1326, 8 U.S. Code, illegal reentry, and they could be deported rather than face that conviction, they're going to always choose deportation because there are some people that are screwed immigration-wise. This is one particular individual. He's screwed immigration-wise. I've advised him of consequences. He wants to be home for the holidays. Okay, no, I
So
understand.
short-sighted, you know, really. I mean,
Short-sighted in terms of what? Immigration law, he's permanent barred. I mean, I can run you through all the sections of the INA. He has no options to get anything, anytime, at any point in the future. So he wants,
if,
it's a waste of
Let's say he
taxpayer
goes-
money, in my opinion, to bench warrant him. Yet Harris County has to go all the way up there to Conroe, or I think they go to Greens Road. Federal government brings them down to Greens Road.
here's my thing. I think it would be unreasonable if he gets deported for me to continue to reset this case. Because that's what you're asking me to do.
I understand.
Indefinitely reset this case.
Well, what I'm asking, look, your docket
Right.
management issues, that's true, that's a docket management problem, but the DA's office, if you look at their dismissal form, one of the boxes is deported. They can always refile the case. That's a docket management issue that they can take care of. But for
But
him to,
can't always refile it because they have a statute of limitations,
well,
you know?
I mean, that's an issue, but I don't see what the basis is to revoke bond off an involuntary violation.
I agree with you. I agree with you.
So where's the, I mean.
But I cannot indefinitely reset a case.
Then what's going to happen?
I don't know. Let's see what they want to do. Perhaps they'll dismiss it. I don't know. Have you spoken to them about that yet?
Yes. They did not want to dismiss it.
Okay, well,
They
there we
offered
go.
the time served.
And if he ends up getting deported, right?
But here's the thing, if you revoke bond on Monday, he's not gonna get deported, because ICE, every time they're about to deport, they do the warrant check, they're gonna see the revocation, and they're gonna bring him back here, and it's probably gonna delay everything, maybe 4 or 5 weeks, cost the federal government money, cost the county money.
Okay with it.
Okay,
County
well,
has plenty of money,
well,
and
then-
it's better in the long run for everybody if we get it back, take care of things the way that they should,
okay.
as opposed to the other way.
And
you
Judge,
know?
I have 2 follow-up questions, which is, then one on Monday, I would like a court reporter for the hearing, because we're gonna appeal that up. And the second thing is, would you agree to reinstate, because he paid the cash bond? He doesn't want to lose $1,000.
State, I need your help, if you don't mind, please.
And just.
So we're in a bit of a conundrum.
We talked about this a little bit.
I just forgot the cost number, 1 second. Thank you.
Judge.
Yeah.
Oh, up there, like, you're not.
Don't worry about it. Look, hey, don't worry about it. Don't. You ready?
Yes, sir.
Okay, so Mr. Perez, he has a prior assault, looks like it was disposed in 21. Is that a conviction?
He has 1 prior conviction, Judge.
Oof,
With the
Yeah.
affirmative family finding.
finding, right. So
2021.
he's got that prior, picks up, I guess, a felony assault in 23 that gets dismissed,
Right,
a felony theft that's also dismissed,
right.
and then now he's picked up a DWI Class A. And I guess what happened was they give him a PR bond like they do, I guess, on every case, and then he ends up going to ICE.
Well, Judge, let me clarify. We actually approached for a PR bond. This court didn't want to give him a PR bond. He had a $1,000 bond. I told him, so this is on me because I didn't read the bond conditions beforehand, but I told him that if he paid the $1,000 bond because he wasn't set until January 7th, knowing immigration, there was a likelihood he was going to be reinstated and deported before January 7th. But the bond violation report was filed because he failed to get an interlock and he failed to report to pretrial. That was an oversight on my part to not look at those conditions. I mean,
It's not a big deal.
I hear you.
I'm never gonna ding someone for.
well, I'll self-ding. I've already done myself.
But, so basically what he's asking for is he's asking, you know, are you guys going to dismiss? These are rhetorical, hypothetical questions. Are you going to dismiss? If not, how do we go forward? Because he's in ICE custody, he's telling me that he's probably going to end up getting deported because he's been removed already once.
Well, I know he was getting deported. I spoke to ICE yesterday. He's awaiting a seat on the airplane.
So they're going to, the problem is that basically what he's asking me to do is not revoke his bond and just let it continue, right?
That's correct, Judge.
That means I would really be indefinitely resetting this case because he'd be getting deported back to his country. And I would literally have a case on my docket for the next 30, 40 years or however long until he comes back, if he comes back, right? And I think that's a little unreasonable, right? So what I suggested is that we bench warrant him back here so we can take care of the case one way or the other, whether you guys dismiss it, whether he pleads somehow. Or in the alternative, I could issue a warrant for his arrest, right? And then that would also be a way that we could get him back here. I think that you're opposed to both of those methods.
That's correct, Judge. I don't think there's a basis in the code for either method.
And we spoke,
So look, don't respond yet. Let's have a hearing on Monday so that everybody here can properly research. Is that a proper way for a bond revocation, right? Can we revoke the bond? Is it a proper revocation or not? I don't want you to answer now, but take time. Let's look over it. You know, I never want to do anything that's wrong, right? I never, ever, right? But I think it's just me holding this case open indefinitely. I just can't do that, man.
It's a conundrum, Judge. I mean, I think about it like this. There's no bond amount that can assure he would appear in the future, right? Even in $1 million bond, right? So, but at the same time, you can't hold a Class A at no bond. You know, I mean, that's
No one's holding him at no bond.
right, but that would be the only alternative. In the case you revoke bond, let's say you revoke bond on Monday, he's back in Harris County custody on Friday.
That's not necessarily true. They may deport him anyways. We have dozens of cases where they've deported him regardless.
I can tell you that in my experience, when ICE does the deportation, they do a warrant check. They'll deport pending charge, they'll deport. But if there's a warrant, if there's a revocation, they will send back to Harris County. That's my
I've seen it
experience.
both ways. It's in their discretion.
If there's a case.
So, but let's regroup on Monday. I mean, how do we go forward? Do we revoke? Do we leave open? Do you guys dismiss? Do you have enough evidence? Can you eval the case if you don't mind? Is it a good case for trial? Is it not? I don't know. But let's regroup on Monday and see how we go forward.
And
You know?
we have a court reporter on Monday?
Yeah, Ramona, are you gonna be here on Monday? No,
Yeah, I'll be here.
she's playing. Yeah, she'll be here.
Okay.
Yeah, okay.
Judge, I appreciate it. Morning, Judge.
Hi.
I just want, one thing I'll say, I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on, so.
This is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is,
I mean, wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm an
Great job.
immigration attorney, Judge, so I mean, and I'm a salaried employee.
Yeah.
Really, great job.
Well, I just mean, if I wasn't a salaried employee, maybe it wouldn't be worth my time. I think that's an issue.
But representation is representation, doesn't matter, you know, really, at the end of the day, everyone is. Shh.
I don't believe that. I mean, I spoke to the ICE supervisor and even he said,
Hold on. We need to go on the record. Sorry, Ms. Thomas, give me a second. Are you ready, Ramona? Okay,
Order in the court, going on the record.
so, Mr. Feldman, what's the last name again?
Carl.
We're on the
Carl.
record.
Have a seat, please.
Thank you. What's his name, last name again?
This is Cesar Moises Capriel Perez. I think he's listed as Moises Perez on the.
Moises Capriel Perez, Judge. I have a cause number.
Yeah, okay, let me have that,
Okay, it's
please.
529290.
Okay, all right, sorry, let's go on the record. All right. We are on the record. It is cause number 252-9290. Today is December 10th, 2024. It's approximately 9:44 in the morning. Parties, I'd like you to announce yourselves for purposes of the record, please. Beginning with the state.
ADA Rojette Saba and ADA Kelsey Siegler here for the state.
And this is Noah Feldman on behalf of the defendant Cesar Moises Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit.
Judge,
I get.
if I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose. So what I just offer this to show that.
Is this his or is this just a generic?
Generic.
Okay.
Exhibit 4 is going to be just proof that he's in ICE custody. It's a print off the ICE.
That's 4.
Exhibit 4.
Okay.
Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer and it looks like I can see the defendant there and it looks like he can look at us as well, but there's no translator. So does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm gonna need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day or I mean, if you don't wanna roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
And that's.
And we did speak
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before. He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. He also did say that the officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may.
Okay.
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean US citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, which is in Exhibit 2, which back after the ICE hold, the state requests a $1,000 bond for the defendant. Defendant posted the bond and without any volition on his own gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defect in the bond. If the bond is excessive, I don't see, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. We could set him at $1 million bond. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, ICE, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number at 936-520-588. Oh, sorry, that's the wrong number. 802-872-6020. And ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country. Now, I think it would be punitive to take away $1,000 from somebody who posted a bond that this court affirmed that the state requested and say, I'm taking away your $1,000 because of actions completely out of your control, actions that are being taken by a third party.
So if I bench warrant him back here, then nothing will happen to that then, right?
A bench warrant is a revocation of bond, because if you bench warrant him, basically you're asking the sheriff to go get him, or you're asking ICE to bring him. ICE has already told Ms. Saba, we're not bringing him. The sheriff, if they go recover him.
No, they haven't said they said they were going to think about it, that they were going to look at it. They didn't say that they weren't going to.
Well, then let me clarify, Judge. If you want to bench warrant and be clear in that bench warrant that this is not a revocation of bond, I have no objection to that bench warrant. It's my opinion.
You had an objection last time to the bench warrant.
I have thought about it some more, Judge. If you bench warrant him, but there's no revocation of bond, I have no objection.
Well, then we're all happy.
But
Are you happy with that?
Yes, Judge, I'm
Great.
fully deferring to you.
Let's do it.
then let me say one more thing, Judge. I would request that on that bench warrant, it be clear this is not a revocation of bond. And let me tell you what.
Go ahead.
Because if you issue a bench warrant and there's no revocation of bond, the sheriff's office is not going to recover the body, because upon recovery of the body, they're going to have to release the body. And ICE could always, while he's in ICE custody, bring him, respect the court's bench warrant, and bring him to the courthouse. I mean, I think he'd be in civil detention the whole time. I don't think they can put him back there.
Sure they
But
can.
Well,
They can.
I don't think they can
Every
make
time we
someone
bench warrant them, they go right back over there.
because they're in county custody by that point. But what I'm saying is ICE can keep him in their custody, which is civil administrative detention, and bring him to court if they so choose. Now,
Try.
they
We'll
can
try.
they
You
can
know?
try to do that, but I would just please ask this court, because I've seen it on
I
numerous
won't revoke
occasions.
it now, but let me ask you this.
Yes,
You
sir.
know, I'm supposed to be fair.
Yes, Judge.
I can't show favoritism, right?
Of course, Judge.
If I were to essentially, if he gets deported and I never revoke his bond, where have you ever heard that happening before? Doesn't that show favoritism toward you?
How would that show favoritism?
Because I'm doing something and I'm allowing your client to remain on bond for eternity when I've never done that with anyone else. Essentially, he's on bond for DWI. He doesn't have to comply with any conditions, no matter where he is, whether he's in Abu Dhabi, whether he's in Africa, whether he's in Mexico, whether he's in Guadalajara. You know, he's supposed to not consume alcohol. He's supposed to be monitored. He's supposed to have an interlock. And thereby, I'm saying, okay, here, look, you don't have to do any of these conditions. Everybody else does, but not you, Mr. Moises Perez.
disagree.
You are so.
I disagree, Judge, and here's why. The state of Texas works very closely with the Department of Homeland Security. The state of Texas, if they want to continue him on bond, which is their choice, because they want to continue the prosecution, they don't want to dismiss and refile, they can always put in a request that he be paroled back into the country for the prosecution, subject to the bond conditions. If you don't think that my client wants to remain in the country and follow your conditions, you are incorrect. We requested release from ICE. We requested that he be able to follow the court's conditions and abide by every single thing you put in that order.
You're apples and oranges. No, it's the point is that he's allowed to remain free on a DWI. Everyone else in our court has to follow a certain set of conditions, yet he's not going to have to follow those.
He should have to follow them.
And Judge,
There's
just
no supervision.
If there's proof
How
of
can I
him,
drug test him?
Judge,
How does he do the
then that's
interlock?
the solution. The solution is either we're.
No. I'm going to bench warrant him. But what I'm trying to get you to understand is that it's not fair. I have to be fair to the state and I have to be fair to you. And I can't show favoritism. And I think that if I were to let him pass indefinitely without revoking the bond, if I were to, we're going to bench warrant now this is theory, right? As a practical matter, I'm going to bench warrant him here for you. But in theory, right, wouldn't it show favoritism? I think it does. Because I'm allowing you and your client to do something that I don't allow anyone else to do.
But wouldn't it be the opposite if you were to take $1,000 from him that he lawfully posted at the request of the state and this court at no fault of his own? I also think that's unprecedented.
I get it, but he's in this country. You know, the right way to do things is you ask for permission, you come here.
Judge, that's completely irrelevant.
Well, no, it's not. It's you must follow the law, period.
But he
And
got
when
the
you don't, there are consequences.
Judge, he was given the $1,000 bond at the state's request
Again,
after we knew he had a final order of
I just
removal.
wanted you to see it from my perspective. That's it.
understand, Judge.
Right. I'm going to bench warrant him for you. I'm not going to revoke the bond. We'll try to get him here for you. If for some reason at that point they don't, we'll cross that bridge when we get there. But we'll try to bench warrant him. Did you want to add anything?
yes, Judge, the officer Hudson did advise me that if you issue a bench warrant, if you want to send me a copy of that, I can email it to him directly and as well as through whatever routes the court does it as well. But I can email it to him directly this morning if you do that.
That's incredibly expeditious because I tell you what, it doesn't happen. You know what I mean? And it's literally when we issue a bench warrant, it takes a while to get to the appropriate person. It takes forever for them to think. It takes 3 months to bench warrant.
Judge.
So this is really expeditious.
I provided all the information, contact information for the ICE officers.
Judge,
Great.
actually,
So that helps, Mr. Feldman, you know?
Judge, just to clarify, the officer that defense tried getting me in touch with was not in charge of this case. Upon sending a message to that officer, he connected me to the supervising officer for this case.
Good job
That's a different-
to both of you guys. You both did good. The
I would just
idea,
ask to be CC'd on all communications.
sure, of course.
Yes,
Everything's transparent here. No one hides anything. And I mean, I don't do the bench warrant. Usually Victoria does it, so I don't know the protocol to it.
Just
But
there's
that,
notification.
so whenever I guess when you send it via email, just if you don't mind CCing him,
Yes, sir, we always CC. Yes,
So-
sir.
of course,
Yeah.
Judge.
you're happy with that?
Yes, Judge, as long as there's no
Is happy
revocation.
too?
Yes, Judge.
Wonderful.
Thank you,
Thank you,
sir.
Judge.
Makes it for such a great, you know,
Thank you. I appreciate it, Judge.
off the record. Hey, guys,
Yes.
Mr. Feldman is zooming back on. Mr. Feldman,
Yes, Judge, give me 1 second. I'm just trying to get my video. There
okay,
it
take
is.
your time. What's going on?
Okay, I apologize. I forgot to get the case reset, so your coordinator called me
It's okay.
about
I
that.
was gonna set it off around 2 weeks, just to give or
Okay.
take. Um,
My only concern is that, my biggest issue was that there be no bond revocation. I'm thinking about this logically. If you bench warrant him without a bond revocation, if the sheriff recovers the body, they should have to release the body because he's on bond.
No. He has an ICE detainer. He cannot leave custody. He will continually be in custody from one time until he gets here. At no point are they ever going just to release him in the free world.
I understand, Judge, but what the sheriff is going to say is they're going to say we need a capias, and the capias can only issue if there's a bond revocation,
What leads you to that conclusion?
because I've seen it in other cases. Or what the
I
what the
will tell
sheriff.
you that every time I have bench warranted someone here, we either get them or we don't. I have never had someone released when they have an ICE detainer.
I don't think he'll be released, but I guess my point is, let's say you bench warrant him. He's posted bond already, right? So he gets put in the county jail. He's on bond.
He still
only-
has the ICE detainer.
Right, I understand. But when you post bond with an ICE detainer, you can be held for up to 48 hours. So basically, you would be authorizing the sheriff's office to take custody of him for 48 hours maximum, right? Because he
No.
already has a bond.
No.
Explain that
Get
to
his
me.
body and he will stay with us here until we do something with the case.
But his bond isn't revoked.
Correct. I can do one of two things. I can either bench warrant or I can revoke the bond. It is duplicitous to do both. So typically we do one or we do the other. I'm just going to bench warrant him back here. They're going to send the bench warrant to the person at immigration. Hopefully that will expedite the process, but I don't know how long it'll be. But if they bring Mr. Perez back, we should get him back here and we will talk with him the next business day.
Are you able, so the,
I think you're overthinking this, Mr. Feldman.
Judge, I'm looking at the code, right? 1503 gives you the authority to bench warrant, right?
What do you want me to do?
I don't want the bond revoked.
I'm not revoking the bond. I reset the case so as to not revoke the bond. All I did was issue a bench warrant. One, there are two vehicles to get Mr. Perez back here to us. One is a bench warrant and one is a revocation of bond. Both achieve the same purpose, which is getting the body back here. You asked me to do the one, so that's what we're doing, you know, as a courtesy to you. I'm not revoking the bond. It will remain intact. We will get his body and he'll just be here and
So
waiting for us to do whatever we're going to do.
will he be held at no bond?
No, he'll just be here, held at the $1,000 bond, saying bond made, but the ICE detainer keeps him here.
But the ICE detainer is only valid for 48 hours.
Not that I've seen. We have people here that sit here months on an ICE detainer.
Your Honor, the detainer itself says so. They sit there months on the ICE detainer because they haven't posted bond.
I don't know what to tell you, Mr. Feldman. I don't know what to tell you. But as soon as we get them, we'll try to do what we can. Hopefully we don't get them on a Saturday. I don't know.
Can you put something in the bench warrant that specifically says bond is not revoked?
I don't know. I mean, I'd have to reach out to my staff lawyer to figure out what kind of implication that would be. You know, I don't know. But I'm telling you, I'm not revoking the bond. I don't know what else I can tell you to give you assurance that I'm not revoking it, you know?
Okay, so when he comes back into custody, it's going to say bond
We'll
made.
try to, yeah, it's still going to say bond active. It'll still say everything that it says now. We've done it many times. Never had an issue. They either give us the body or they don't. It just depends on what ICE does, because sometimes they follow it, sometimes they don't. Sometimes they just go ahead and deport. I've seen it both ways.
And Judge, when I spoke to his officer this morning, the one handling the ICE case, he told me whenever they receive bench warrants, they don't always, you know,
Comply.
they don't always comply. You know, with this, I can speak to him and try to get him here, but at the end of the day,
First, no.
they're gonna do
But
what they
first,
want.
you know, talk to your superiors to see, you know, is that going above and beyond? Because I don't want you to do anything that's going to get you in trouble.
That's true.
Remember? So
And that's what I was
always
trying to tell this
consider, you know, before you just, because that's a lot.
Yeah,
I don't want you to do anything that's going to get you in trouble because you have certain boundaries and certain things that you got to do as well, like I and like him. So we'll give you a copy of it.
okay,
Reach out to your people and see, hey, is this okay? If so, then yeah, send it, right?
okay.
And then attach Mr. Feldman so that we're all on the same page. And hopefully that, if you can, that'll expedite everything. Regardless, we're going to send the bench warrant regardless. But with you guys and with the intervention, if you can, hopefully that'll expedite everything. And hopefully they will comply with it. Because I have, and I'll tell you, Mr. Feldman, I have no idea why they comply when they do and why they don't comply what they do. I don't know, you know, I don't. No one has ever told us either way why they do or they don't. I just don't know. We'll do everything we can to try to get them back. If we can, wonderful. If not, we'll cross that bridge and we'll do what we can when we get there.
And Judge, will in terms of the issuance of the bench warrant and the communications with the sheriff, will you also CC defense counsel on that?
When you send the bench warrant, who do you send it to?
So I generate it and give it to the clerk. The clerk sends it into different drop boxes and images.
So you don't CC any, you don't like email it. No, there's a certain process that they have when they send the bench warrant. They don't email it. There's a drop box that they do. So there's really no way to attach you to that. If they email it to the person, then the DAs can attach you. But with the actual here filing of it, there's no way to attach you. It goes to like a Dropbox of some sort.
If I can just say one last thing, Judge, and I know I'm being annoying and I'll leave.
Mr. Feldman, we have thick skin. You're not annoying. You're doing your job, and I'm not going to begrudge you for doing it.
Okay. What I would guess is that in cases where you bench warrant and the person's sitting in jail waiting for the hearing, my guess is that the sheriff has revoked bond.
Sheriff cannot revoke a bond, Mr. Feldman.
I agree with you, Judge. I agree.
They can't.
But I'm just saying that when you're in jail and you post bond and you have an ICE detainer, the county can hold for 48 hours. And you're telling me that you see it
When we bench warrant them back, it's different. When we bench warrant them back, we will get them and they'll stay here. And I'm telling you that from the experience that we've had.
Right, I understand. But I'm just saying, if he gets bench warranted back and he has a valid bond, I'm going to go to the sheriff's office and I'm going to tell them that y'all have 48 hours to keep him on the detainer because he can't be held at no bond.
Then I'm going to revoke his bond, Mr. Feldman. I mean, if you're telling the sheriff's office to go release him, then I'm going to revoke his bond because that's what it sounds like you're trying to do.
It's not, Judge. It's not. What I want is no bond revocation.
Hey, don't overthink it. You're perhaps maybe putting fuel on a fire. I don't know. I don't know what you want, but we're going to follow a process that we've always done. I'm not going to deviate from it, right? We do things a certain way. That's it. I'm not going to do anything special for your guy that I wouldn't do to anyone else in the entire world. I'm going to follow the law and I'm going to continue the way that I see that it should be done. And the way is we either revoke or we issue the bench warrant. We're going to try to get the body back. If for some reason someone releases him or whatnot, we'll deal with that, how that happens. But, much more than that, I can't tell you. I don't know they're either going to give him to us or they're not going to give him to us. And that's it.
Yes, Judge.
I mean, if you're telling me that you're going to go to the sheriff's office and demand that they release him within 48 hours, I got to go upstairs and talk to a couple people to see how to go forward on this thing. Because I don't know. It's a new one to me,
And Judge, at that point, the state would ask that we revoke the bond, if that's what defense is planning to do. We agree with you.
And let's just see what happens, Judge.
Judge, we're going to need.
But I have a feeling that you're now going to the sheriff's office to demand his release within 48 hours of recovery.
And Judge, this is putting us in a compromising position as well, because if this is what defense is planning to do, we need to let ICE know. We may need to do that. I need to check with my superiors.
I don't have a problem with letting ICE know.
I don't know what to do here, Judge. I thought we were doing the no revoking the bond as a favor to defense because this isn't customary when we issue a bench warrant. But if defense is going to, in a way, abuse that to get him released, then the state is taking issues with that.
I do too.
Judge, I wouldn't be abusing it.
I mean, if that's what you're going to do, I'm going to end up revoking the bond, I guess, because I think that you're trying to go behind our backs. It's, I really.
Well, Judge, why don't we do this? Why don't we do this? Why don't we do the bench warrant as needed? And if they've recovered the body, then we'll have another hearing, obviously, to figure out what we're going to do. I'm not going to go behind the court's back, but
Mr. Feldman, let me tell you something that you need to be careful what you do. There is a fine line between zealously advocating for your client and doing something that either breaks the law, is unethical, that could get you in potential trouble. You need to be very careful. You really do. There's a fine line. I've seen a lot of lawyers get in trouble, and I'm just counseling you as, I guess as a friend, but I guess, I get that you're zealous, but just be careful, you know?
Yes, Judge. I promise you, I'm going to follow the code and I'm going to follow the rules of ethics.
I guess, Judge, are you still planning at this point to issue a bench warrant without revoking the bond?
Yeah.
Okay,
Good.
and then,
We'll see. What happens, happens. We'll see. We'll let it play out. I mean, we're all adults. We'll see how it pans out. You know, you do what you think is right, and we'll just go from there.
okay, Judge, thank you, Judge.
Okay?
Thank you, Judge. May I be excused?
All right. You got it, Mr. Feldman.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.